my presentation with you. And if someone can perhaps just confirm to me, thumbs up or anything, that you can indeed see my slides right now. Verbally, even Vojani, maybe you can just tell me
we can
that
see
everything. Perfect. Okay, let me click all these buttons. Okay, perfect. All right. Once again, good afternoon, I think, for most of us here. Vojani already very kindly agreed to me, as you can see on the slide in front of you. I'm an associate professor here at the University of Cape Town, directing 2 units, obviously a lot of work on intellectual property in the past, but I'm also now leading the Intaka Center for Law and Technology, and I think it is that function that brings me here this afternoon to talk with you a little bit about smart contracts and electronic contracts, perhaps also a little bit more broadly. Just a few words perhaps before I start on the Intaka Center, because it is it's a relatively recent entity, and we started it a few years back, and our main aim really was to tackle that intersection between law and technology a little bit better. We felt we're not doing enough on this yet, felt a little bit awkward of how these two areas intersect and how well they do this. And we wanted to just really start to better prepare also our students, but also then practitioners like yourself for those pretty rapid changes that we are facing currently. So this whole space can be quite daunting, and it certainly takes many of us, including myself, still very much out of our comfort zone. And I will show you a little bit of computer code later, unfortunately, too, and that's quite cryptic. But what I really want to always do at the outset when having these kind of conversations is that I want you to at least consider embracing these technologies a little bit. It can be quite a useful tool that can make our work ultimately, once we open up to them, more efficient. So just to give you a practical example of this, if you're looking at the title for today's seminar, that when Vanya Karth asked me to propose a title, that it was already pretty late in the day, and I was chasing a couple of deadlines on that day. So I thought about it for a few minutes, had a bit of a writing block then, and then I decided, you know what, I'd rather use generative AI for helping me to create a title for me. And I put it into one of these AI tools that we have these days. And sure enough, what you see in front of you was one of the proposals that AI system provided us with. And I think it's a pretty decent one. So it did a decent enough job, I think. But at the same time, and I was reminded of this on Friday, I'm also under no illusion whatsoever that what we will be discussing here today is probably not something that you're dealing with on a day-to-day basis. And as a matter of fact, we had one of yours, regional magistrate Anthea Ramos. I'm not sure whether she's in the audience here today, but we had her talk to our Intaka Center students last Friday. And our students were obviously quite interested in what's happening in the space. And she told our students that legal technology really, at least in her work context, is not something that is yet widely used. Certainly something that will change over time, but it's not something that is yet something that forms part of her daily duties. Nor does she deal with a lot of cases involving technology yet. Again, might change, but certainly right now that's not the case. So what we're talking here about is a bit of a glimpse perhaps into the future for many of you still, but I think it is pretty safe to assume that change will happen in this space. So hopefully the session will help you to prepare what's coming our way. The session today is on smart contracts, but before I start to explain to you what they are and what some of the legal issues are that they raise, I thought I'm going to take one step back and start off with telling you a little bit about, I guess, the fundamental question at the intersection between contracting and technology at the moment, one that applies to all contracts, really, not only smart contracts. And that is if and how you can actually contract electronically and online. Now, I'm pretty sure that probably all of you in the audience know more about contract law in general than I do, as you can hear from the way that I talk. I'm not from South Africa. I got my LLB degree a long time ago in Germany. And even though I've been here more than 20 years, I've been focusing on other areas of law than contract law. But I think it's worthwhile for all of us, even though you know quite a bit about contract law already, to come back to some of the key principles of contract law, and then ask ourselves how those principles can be applied in the electronic and online space. And I hope that this will then also sort of enable us to identify areas which remain problematic. And it is also a nice basis for then discussing smart contracts in a bit more detail. Again, not exactly sure who is in the audience today, but my understanding is that typically there's not only judicial officers from South Africa in the audience, but what I obviously can't do is to deal with all legal frameworks for electronic contracting and smart contracts in Africa in any sort of detail. I don't think anybody can do this well, especially in the time frame that I was given. But what I will try to do is to provide you with the skills needed to ask the right questions and to be aware of the key issues that arise. As we do that, as we go along, I will use some examples from across Africa, and admittedly, more often than not, I will then talk about the South African situation firstly because I know most about that, and also because it has a relatively mature regulation of electronic contracting in its Electronic Communications and Transactions Act of 2002. Okay, so this is how I want to structure today's seminar. Roughly, first, I want to remind us all of some of the underlying international key principles and electronic contracting. Then I want to talk a little bit more about specifically about contracting with a computer and automated transactions, which already overlaps with the third bullet point then that you see on the slide here, and that is then the focus on smart contracts in the end. And also, Bojani, I'm not monitoring the actual chat or anything at the moment. If anybody has a question that is pressing, when we should stop, just feel completely free to just interrupt me, because I'm not sure whether I will be seeing that if there's a visual cue for that. Okay, perfect. Thank you very much. So this is the starting point for our discussions today, and that is that I guess we all know that nowadays many products, services are offered online. Sometimes they're even exclusively offered online, and we can't even get them in a brick and mortar space any longer. Those what you see here are some of the international and local examples of platforms for online goods and services. I'm sure many of you have made use of some of these already. I should probably, with the arrival of Amazon in South Africa, the marketplace that is, I should probably have added that here as well. But surely for the South Africans, the Superbalist, the Takealots, and also Ubers and so forth, obviously, ring a bell. And this is the kind of law that we are still trying to have to apply to some of these new online offerings. They oftentimes predate online contracting, and they also predate the internet as we know it, and that is not without difficulties. So there's a lot of uncertainties and a number of issues which keep coming up in this context as a result. So here are the key issues that I have identified as at least flagging and briefly talking about. And the first one is, so are these contracts that are concluded electronically valid? What about formalities? When is contracting actually happening if the people are not sitting in the same place when they contract with one another? What about standard terms and conditions? Can they be included in electronic contracts, and how? Then very much close to the issue of smart contracts. What about contracting with human intervention? and also questions about applicable law, although I have kind of spared us that component, and we perhaps leave that for another time, for another presentation. So let's look at international key principles in electronic contracting first. The first thing that we need to realize, as daunting as it is for the lawmaker in the country, and that can be statute and or case law, is that obviously as countries here in Africa, we don't have to start from scratch. We don't have to do this all by ourselves and alone. Other countries have dealt with that before. In fact, the international community has a long time ago already started to think about these things. And in fact, much domestic lawmaking in the space is based on these international efforts, which try to really harmonize national legal regimes in this area. And what you see here in front of you is one, not the only one, but certainly one of the most important instruments that I want to single out. And then that is the UNCITRAL model law in electronic commerce. And as you can see, it's not the freshest piece. It's from 1996. And it's also not a binding convention. But many countries, including South Africa, have used this model law as the groundwork for how they have then subsequently dealt with the issues in their respective laws, including South Africa with its Electronic Communications and Transactions Act that you see a screenshot of here on your screen, clearly based on the UNCITRAL model law provisions. There's really, and I'm almost done with that kind of general introduction here, there's really three key principles that I want you to kind of perhaps take with from the seminar that the UNCITRAL model law contains. And the first principle is the principle of non-discrimination. And according to that principle, a document may not be denied legal effect, validity, or enforceability just on the grounds that it is in electronic format. The second principle is then the principle of tech neutrality, according to which provisions should be neutral with respect to the technology that is being used. Now, this principle, like also the first principle, is logical, and I can understand where this is coming from, but I just want to flag here, and this is again for a different talk, that this has worked so far, but I think going forward we need to rethink that. We might have to rethink that that principle a little bit in the context of artificial intelligence, because this really is a very disruptive technology, and the massive changes that have come as a result of artificial intelligence, I think, may require us to also think about legislating tech specifically in that context. But that's just a side note, and maybe just a research interest of mine. The third principle in the UNCITRAL model is the principle of functional equivalence. And this principle spells, in essence, out criteria under which electronic communications may be considered equivalent to paper-based communications. And then it also determines when certain notions of the paper-based environment are met. So let's become a little bit more specific then on the domestic level, after telling you what the international framework roughly asked us to do. And let's look first at validity of electronic contracts and place and time of contracting. So most of us will know, of course, that a valid contract, for a valid contract, you need an offer and an unconditional acceptance. Conditional acceptance is usually seen that as a new counter offer. So the first question we need to ask ourselves really is whether such offers and acceptances can be made electronically. And in the best of cases, you have what we have here, what you can see here happening in Kenya and South Africa, and that is that your domestic laws actually clarifies specifically as to whether this is the case or not. Here, both laws, if you look at the Kenyan law and the Kenyan Information and Communications Act and the South African Electronic Communications and Transactions Act, both laws here confirm that in principle, the answer to the question as to whether offer and acceptances can be made digitally or electronically is yes. So we have that answer in our law. Once we have established that contracts can be concluded electronically, then another second important question arises, and then is when and where do these electronic messages become effective? And the reason for this is because in the electronic space, the person sending the message, the offer or the acceptance, has actually often no way of knowing whether the other party now has received or taken notice of that message. And under contract law, what is typically required when it comes to these kind of indirect offers and acceptances is subjective notice of the offer that by the person receiving the offer. So what it really means is that person needs to read it. And on the acceptance side, acceptance typically occurs with a dispatch of the acceptance once you send them off. Only that several countries, including this country, have in the context of electronic messages deviated from that general rule and now instead require that the acceptance is not only dispatched, but it is also actually received by the person making the offer. So just an important deviation from the general rule in this context. Now moving from validity and place of time of contracting to the next issue, and that is formalities. Let me say a few words about this. First in general, but also because I want to return to this a bit when I talk finally in more detail about smart contracts. So again, I suppose, as most of us here know today, is that contracts do not require formalities. But some contracts do, or the parties decide that they prescribe them. And some of the typical formalities you can see here on the screen, they include the in-writing requirement, the requirement to have a signature, or the requirement for notarization. And already back in the 1990s, the UNCITRAL model that I talked about earlier, through its functional equivalence principle that I mentioned, stated how certain paper-based concepts can be satisfied in the digital space. Several domestic laws on the continent now dealing with electronic communications have since introduced similar provisions. And again, just to make sure that we are not only talking about South Africa, at Kenya earlier, here you have an example from the Ghanaian Electronic Transactions Act of 2008. And this provision, for example, stipulates that in principle, the in-writing stipulates for the in-writing requirement that where a law provides that information shall be in writing, that requirement shall be deemed to have been satisfied if the information is first available in an electronic form, second accessible, and third capable of being retained. And we have similar provisions in the Electronic Communications and Transactions Act here in South Africa. Carrying on with the same piece of legislation, it also clearly spells out then in section 15 when notarization requirement is met in the digital space. And what you can see here is that provision then requires an electronic signature being used by the notary. And that brings me to the last type of formality that I quickly want to talk about, and that is the signature requirement. And this is how it's being dealt with in the Electronic Communications and Transactions Act. And obviously, I will spare you the details of this provision as you can see it here in front of you. Suffice to say, it's a bit complicated. And what I do for you, as I do with my students typically, I give you a bit of a summary of the provision as I understand it. And that is that the provision essentially says that if a signature is required by the parties not by law, but by the parties, then all we need is a simple data message that identifies the person and indicates the person's approval. That can be, for example, a scanned-in signature. Doesn't have to be one necessarily. However, if a signature is required by law for the contract, for the agreement that we're talking about, then we need a so-called advanced electronic signature here in South Africa. And I think it's pretty safe to say that the whole concept of advanced electronic signatures really hasn't taken off here in the country as intended. I'm not sure whether anybody in the audience has made use of them. I've tried it once or twice, and it is a very cumbersome progress, I have to say. So it's not being widely used. So there's definitely some more work needed to align what's in the law with realities, I guess. Next, I want to talk about standard terms and conditions. And I guess what some of you may have heard about is these two historic ways of incorporating online terms and conditions into a contract. The first is referred to as a browse rep. And in that case, the users of a web service essentially are being told that by merely using the website, they also then agree to the website's terms and conditions. So you browse the website, you agree to our terms and conditions. Click wrap, on the other hand, is the more active approval of these terms and conditions, not as passive as the browse wrap agreement. And that click wrap would require users to actively click a button to confirm that they agree to be bound by the service's online terms and conditions. I guess, again, as humans, we have all made use of these kind of boxes and perhaps too quickly press the yes button. Now, just the fact that these two types of incorporation exist in practice doesn't, of course, mean that these forms of incorporation are necessarily valid. And whether they are valid will depend on domestic law again, and will usually take into account whether a reasonable person would have noticed the reference to the terms and whether they are sufficiently accessible. And you can see here on the slide that this is what Section 11 of the South African ECT Act says. And ultimately, final determinations will often be made on a case-to-case basis, depending on the actual circumstances of the case. All right, so we are edging ever closer to the actual issue of smart contracting, but I think without knowing what I've just told you in the last 20 or so minutes, we cannot meaningfully discuss smart contracts. So few words here on contracting with a computer and automated transactions. Many of us probably have already engaged with automated systems to enter into some form of contractual relationships in the past. That might be either in the workspace, and here in that space, increasingly smart contracts are actually being used, or privately, and that is when you make use of these websites that you can see here, the Takealot, that Jumia's in other parts of Africa, and so forth. Now, to avoid uncertainties, domestic laws should really expressly state that such contracts are in general valid. And one example of such a clause is Section 20 of the South African ECT Act, and also, like, for example, Section 17 of the Ghanaian Electronic Transactions Act. But assuming that such contracts are then valid in the country that you're working with, the next question then is, what happens when mistakes are made, if mistakes were made? If a customer, for example, say ordered 100 instead of just 10 items online, And here common law principles may help, but again, several countries on the continent have already specifically addressed the situation in their legislation. And what has emerged so far, if you look at the different pieces of legislation, at least the ones that I've seen, is that while the person using the automated system will typically be bound what that system does, the natural person on the other side, the one interacting with that automated system, must then always be given an opportunity to review the transaction before the contract is formed. Otherwise, that person interacting with the automated system, with the electronic agent, is not going to be bound by the terms of the agreement. This is important. This is why if you order on Takealot, you will always have that option in the end. You always must be given that option to review the entire transaction before you finally commit. Also, in addition, material errors on the side of the natural person, again, the one interacting with the electronic system, can prevent the formation of a contract if the error could not easily be prevented or corrected, and if the natural person notifies the other person as soon as possible. So there is obviously the need for protecting the person that is interacting with an automatic system more than the person who is utilizing that system in the first place. I want you to remember Section 20 because it is really important in the context of smart contracts. I don't have an answer for that, unfortunately, yet, as there are so many answers missing in this context. But I think Section 20 needs to be definitely interrogated more in the future when it comes to assessing the validity of smart contracts. And with that, I want to go into smart contracts a little bit more. Part of the reason why I structured this presentation in the way that I did is because I think up to now you all felt probably reasonably comfortable with what I told you. Not that you needed, maybe you didn't know about all the provisions that I was mentioning to you, but when I showed them to you, you had something to work with that you feel comfortable with. And that is difficult and different with smart contracts. And I didn't want to start off with putting you off by showing you something like this, because that's a smart contract. Very simple one, admittedly, but I guess a more complicated one would be even more confusing because it would just continue to look like this, only that it's longer. This is computer code, obviously, and most of us can't program. I'm not sure whether that's a different conversation, because I always wanted my students and also my children to be able to code, because I think it's something that is going to be quite important in the future. And only that, again, with generative AI system, perhaps the need has diminished a little bit, because now you can tell an AI system what you want to have programmed, and then that system, these systems increasingly can do that for you. So perhaps that is a skill set that we thought 2-3 years ago is future-proof, and perhaps isn't quite as future-proof as we had thought. Anyways, different conversation for a different day. But well, here you have it. This is a smart contract, and most of us do not know how to make one. I know this a little bit because we do this sometimes for fun. Here you can see 2 photos from a few years back where we made our cyber law students at UCT program such a contract. On the right-hand side, you can see what they did. And that looks very similar to what you see at the top of the slide. And on the left side, you see a photo of our students in the computer lab. And many of them felt pretty much out of their comfort zone, I can tell you at the beginning, but they enjoyed the process. We did this not so much to enable them to do it again afterwards. I don't really think they would have been able to. It was very rushed, but for us it was more important for them to understand the principle, or what in general this really is all about. But even for me, and I've seen a few of those now and done this exercise myself as well, this still looks pretty cryptic to me, and nothing like a contract really. So that's the one confusing part. What I also find pretty confusing is then if you actually read up on it, as I have done several times and also in preparation for the seminar again, you come across these general definitions of smart contracts. And this is the one that comes always up. Whether it was 1994, 1996, I'm not so sure about, but it was in the 1990s. And Nick Szabo was definitely one of the early thinkers. He, I think, might have even coined the term smart contract. And here's a definition: a set of promises specified in digital form, including protocol within which parties perform based on these promises. What? So again, these definitions are not always particularly helpful. And then you add to that whole dimension of that people then say, and all this happens on the blockchain, and that's where it's stored. And some of us may have made some money with cryptocurrency, so they may know what blockchain technology really entails. But again, I'm assuming that the majority of us here on the seminar today don't really know what that is. So this together with definitions that don't help, and then this whole concept of blockchain, which really is not that easy to comprehend, really leaves us like this oftentimes. And by the way, also this is a picture, and I do this increasingly for my presentations, if for no other reason than copyright reasons, that was generated by an AI system for me, so it didn't exist before. Anyways, let me try to unpack the last 2 or so slides a little bit for you and explain this as good as I can. Firstly, the area of application for a smart contract is a situation where 2 or more parties agree that a certain event should trigger a certain outcome. And that smart contract is then written, as you could see, as a piece of computer code that really works in a very simple way. And that way is, it is an if, or when something happens, then something else happens. That's a statement. If I do this, then that happens. Executes by itself. Most people, and I do this too because I kind of like it, use the analogy of a vending machine to explain this better. When I came, let's use these $signs as South African Rand sign because it would work quite nicely. When I arrived in South Africa, I can remember very well that 1 can of cool drink cost about 3 Rand, which is not the case any longer, but it works well with that graphic here. So same here, 1 can of cool drink costs 3 Rand. And that means if you just put 1 Rand in, if you put 1 Rand in, then nothing happens. That's coded into, you don't need 1 Rand, you need 3 Rand. If you put in total 3 Rand in to the vending machine, that's the smart contract, you get a can of cool drink. If you put 4 Rand in, you get a can of cool drink and 1 Rand back. So it's these typical, it's very simple. If you do this, then that outcome is being triggered. That's really what a smart contract is. So about this slide, I thought hard and long because it could have opened a whole rabbit hole. And again, I think while it is at some point probably useful for you to better understand what a blockchain is, I think it would take too much time and be more confusing than anything to really explain in detail now what a blockchain is. What you, for the purposes of today, what you need to know is that the smart contracts, these pieces of software, if-then statements in software form, are then sent to and stored on a blockchain system. There's different ones on a blockchain system. In fact, let me rephrase this a little bit from my own experience from doing this with my students and under the guidance of a computer scientist. What actually happens is you sit on a computer and you know that you want to create that smart contract that says if you pay 3 Rand, you get a cool drink. You're coding this directly, you link your computer to the blockchain system and you code it directly on that blockchain. It's written directly on the blockchain. That's how I remember it. But ultimately it resides, that little piece of software resides on the blockchain. So how much do you need to know about the blockchain? And for now, really, you know that there's always these kind of definitions. Perhaps you've heard it of decentralized ledger systems and so forth. But for now, I think what's really important for you to know is that start of a decentralized network of computers that is constructed in such a way through encryption and all sorts of technical things, constructed in such a way that it makes it almost impossible to tamper with. Tamper with whatever is stored on the blockchain. So whatever is on the blockchain is correct because of the way in which the blockchain works. And people more knowledgeable than us in the tech field have looked at that very closely. And while it is still possible to tamper with it, it's highly, highly, highly unlikely. It requires massive computing power to be able to forge something that is on a contract that is sitting on the blockchain. Because that's just, and I'm actually going further than I wanted to, but that is because at any given time there will be many, many, many versions of that contract, of that same contract. And if one is being tampered with, the fact that all the other ones look different will trigger kind of the network to realize that that one version that has been tampered with is not the correct one. It's kicked out on a very high level. And this is why if you assume, and I ask you to please assume this with me for the purposes of this is why smart contracts can be safely stored and executed on the blockchain because of the way that in which the blockchain operates. We don't need an intermediary like a bank or law firm to tell us that what is there is correct, because it's the technology and the way in which the technology is being constructed enables us to know that that things can't be tampered with. The contract, as we find it on the blockchain, is correct. Every time something happens to a contract, when there is a transaction completed, the blockchain in its entirety is being updated. And all the transactions that happen to that smart contract are also trackable and cannot be changed afterwards anymore. Can post and another block is added to it with a new transaction being captured. Cannot go back into. That's why it's a chain of blocks. Again, I'm catching myself here going into more detail than I should for the purposes of this this presentation here. But it's the backbone of where smart contracts reside and why they, I guess, they can be trusted in a non-legal kind of a way. Okay, so this is arguably my favorite slide, not from how it looks, but what it says. And because it's kind of surprising and perhaps also somewhat disappointing that if you really look at it, we use the term smart contracts all the time. But if you actually really look at it, they are neither smart, really. It's just a simple if-when function. Nothing smart about this, no thinking required, really. It's a statement computer statement that couldn't be any simpler. Nor is it really a contract. It's the way in which a contract is being kind of executed, if you wish. But it's not really a contract. There's no legal language, no legal terms in that computer code that I showed you. Only code that then executes actions when certain conditions are met. So I guess that's the key takeaway also in a way. Smart contracts is a bit of a misnomer in that way, or maybe not even a bit. But there are, looks unbalanced here, but there are significant pros and some cons to the use of smart contracts. There's definitely benefits in the security and the trust and the transparency. There's definitely increased speed. When something is executed automatically by a piece of software and humans are actually not involved in having to make sure that something really happened and verify that. So there's efficiency gains too, and it's typically quite accurate. And as a result, it's usually a cost saving measure as well. But there are a couple of disadvantages too. For example, if you realize that there is a mistake in your smart contract, it's not easy to rectify it. You have to do a bit of a workaround. If you want to rectify a mistake in a smart contract, either you need to come up with a new contract and code that reverses the other one, or that new contract that you write then modifies the effects of the effects that you didn't want from the previous contract. Also, not all codes are perfectly coded, so there can be loopholes. And once people know of these loopholes, because they can't be easily done away with, these loopholes in the code can relatively easily be exploited then. And I guess perhaps that's technical from a legal mind perspective. It also, perhaps a little bit disappointingly, smart contracts really cannot be applied for a huge variety of contractual situations, because they can't really deal with discretion or reasonableness or judgment. And many contracts that you are dealing with, I suppose, have that built in by use of human languages. It always needs to be a clear enough situation that basically says if something happens, then something else happens. So it needs to be what is referred to as algorithmically determinable solution. Okay. With that in mind, and I have just another slide later, a link to a short video clip that actually has a real world application of one of these contracts, because I thought at the end when I was preparing for this that you probably wouldn't need this for peace of mind to really feel that you have understood what we were talking about. But I wanted to unpack a couple of legal issues with smart contracts, because I think that is one of the main purposes of this. First, I wanted to explain a little bit better what a smart contract is, which I have done on a very high level, piece of code, neither really smart nor really a contract. It's an if and when computer code statement that is housed on a safe computer network that makes it almost impossible to tamper with. What are some of the legal issues then that we are having with these so-called smart contracts? First of all, it's coming back to that, I guess, tech neutrality principle from earlier. Just because we are having to deal with a new innovative technology doesn't mean that we cannot rely on our existing legal frameworks and rules. They may just as well be interpreted in a way that they quite satisfactorily address issues that can arise. But one key issue Again, something that you probably know much better than I do. One key issue that arises in the context of normal contracts is the issue of performance, or the lack thereof. Has the person performed in the way that the contract spelled it out? Those are the questions. And what happens if the person did not, or partially did not? But this is not the case with smart contracts. The issue of performance is hardly ever an issue, because smart contracts are automated. They only work on that. If something happened, then automatically something else happens. So they are actually by design geared towards ensuring performance. Performance is always, almost always there. Both parties have performed without having to involve the courts here. So it's actually almost like a means of not having to involve the courts, because if a contract executes in the way that it was programmed, it will mean that the one person did something as required by the code and by the parties before that. And then as a result, something else was triggered. Something was done in return for what the other party did. And that is what the parties wanted. So performance is almost always there. Partially that is also the case because computer code has far less terms than human language. So there is just far less scope for ambiguities. So as a result of that, and that could have been the end of this presentation in a way, some have argued that, well, because performance is never a problem in these smart contracts, they will only trigger the response, the contribution of the other party, once the first party has done what they were supposed to do. So as a result, the legal system is not really necessary for dealing with these transactions. That's where the term code is law, or computer code is law, comes in. And because the code is also the law, there cannot be any legal disputes over the terms of the agreement. That's been argued by some. And if that was true, we would probably not need the seminar, because it's obviously not true, as I will show you on the next few slides. So what are the legal issues then, if they are not on the performance side? What are the legal issues with smart contracts then? So I think this nicely summarizes where they can be. They can either be on the contract formation side, and that is why I talked to you partially earlier through how electronic contracts can legally be formed. So did the contract adhere to this? Was the contract legally validly formed? There's questions around contract modifications, but they are difficult because of the way in which blockchain technology works, as I explained to you. So I put this in brackets. And then there's also questions about, is the contract enforceable? Is it legally enforceable? One important thing I wanted to add to the slide here is that because of the automated nature of these smart contracts, the performance that is always there, what will happen is that the aggrieved party will typically go to the courts only when the contract has already been executed. So they are looking for restorative remedies rather than performance here. Okay, so first thing to remember is that as far as the formation and the enforcement of contracts are concerned, all the usual defenses apply that you, I guess, in your work deal with probably frequently. Were the required formalities for some contracts adhered to? Is there reasons for illegality of the contract? Is there unfairness of terms in there? And are we dealing with consumer protection considerations? Here, I think you are in kind of well-known waters in a way, but don't forget when you're dealing with that, also about that Section 20 of the ECT Act that deals with automated transactions and what is required in these automated transactions that I mentioned to you earlier, like the review possibility, etc. I think particularly important in this context are the provisions of the Consumer Protection Act. I think I put them on the slide. Let me see. Yeah, here it is. In particular, the part in the Consumer Protection Act about unfair, unreasonable, and unjust contract terms in Section 48. Because there are quite a few stories that I came across about abusive terms imposed by companies in electronic contracts and smart contracts also, especially if there are situations of unequal bargaining power. So if the one provides the smart contract and the other one is just the user, the user typically really does not know fully what the smart contract conditions are. So please be aware that especially also Consumer Protection Act provisions here may play a role for determining whether legally valid contracts were formed and whether they can be enforced. As you will have noticed already, because I know I'm talking to practitioners, and practitioners like to hear case law precedent. There is not much on this. So I just came, and that's here now an overseas case from Canada, but I thought I still bring the case to your attention because it is something that could work out in a similar way in South Africa. It involved Uber in Canada, and if I remember correctly, it was that the electronic contract that Uber concluded with one of the drivers had a clause for mediation and arbitration in it that said that arbitration and mediation needs to happen in the Netherlands. And obviously for someone in Canada to do this then in the Netherlands, that triggers quite a high amount of cost, and the Supreme Court in Canada dealt with that and said that this was not validly included in the contract as a result. All right, those are the main issues. I hope I made it clear for you that where the entry point is for your normal kind of contract law knowledge, where the peg is for getting that in. And the question is then, are these really all the legal concerns, mainly the contract law concerns we covered? But that's not all. I didn't want to open a couple of other cans of worms here, but I was intrigued found quite a few websites on this, but I was particularly intrigued by this website because, again, this person who is a lawyer in the US and has been working quite a few years in the space of technology law and has also written a book, or I think, yes, they're on AI and the law. He and his team actually came together and listed what they think are the 10 biggest legal issues with blockchains and smart contracts. And I looked at the list first, and it looked pretty decent. And here's a snapshot from that, and I'll talk about this in a second. But then relatively early on in the blog post, or in that website post, he also admitted that he actually started off with an AI system and asked an AI system, what are the main regulatory issues? and legal issues with blockchains and smart contracts. And then they revisited the suggestions by the AI system, and most of the suggestions he said the AI system made were actually quite spot on. So jurisdictional issues are a problem. Data privacy issues are also an issue that I think we need to going forward deal with more. Particularly, and I didn't explain this when I talked about blockchains, but everything on the blockchain is in principle openly accessible to everyone. So if what you put onto the blockchain, the information that you put onto the blockchain includes personal data, then that triggers potential data privacy concerns. There might be IP issues there as well, issues of liability and dispute resolution. And also because there's different blockchain systems on which the smart contracts reside, people have also asked questions about interoperability, even though this might actually, if I look at it now, not be a legal but more practical issue. So if you want to know more about any of these issues, please follow the link that I put onto the slide. I'm assuming that the slides will be circulated afterwards. And then I think that was literally in the 5 minutes or so before this presentation that I decided, okay, let me also put this in here, because I went through my presentation earlier again. And while I hope it gave you some more clarity, if nothing else, that you actually now know it's not really a contract, not very smart. It's a piece of computer software that is pretty simple and only made for simple kind of situations and not for more complex contracts and a few other things that I mentioned. I still have the feeling that this was kind of being all mentioned in a kind of theoretical frame. So I thought, okay, let me just at least provide the audience with a link to 3 real-life examples in a YouTube clip. So this is a last-minute addition to the slides. So with this, I thank you for your attention. I hope we demystified smart contracts a little more, and I'm looking forward to your question. Bojani?
Thank you so much, Toby. I learned a few things. I didn't know smart contracts were used for small transactions. I thought it was more complex than that. Now it's time to hand over to the audience for a question and answer session. So you can either write on the chat box, or you can just simply unmute yourself and ask the question, and it shall be answered. And I'm handing over to the attendees.
And I absolutely don't blame you for not having questions. I know how confusing this is. I'm teaching this to my students, and it takes a while for them to warm up to the whole concept of smart contracting. I'm trying to find the chat also, by the way.
I was going to say that I am probably more befuddled than I was at the start of
I'm sorry, Vanya.
I have a question.
Sure.
Sure, Yaki, you can go ahead.
Okay, it's Maraj here, ARCP from KZN. Good evening.
Welcome.
Thank you. You know, when you go on some sites to read, like Google or News 24, they have a pop-up to say, I am not a robot. They want you to verify that you're not a robot, and you click on that, and then you can read the news. In the issue of smart contracts, would that make any difference? My other question is this: who pops up this idea that to verify that I am not a robot? And if AI is so-called intelligent, will they not answer that question? A robot will say, I am not a robot. And will that affect any smart contracts?
Okay, shall we, while I ponder, is there other questions as well? No other questions?
Just one. So maybe you should answer that. Maybe that could trigger further questions from other people.
Right. I'm still doing, just before I do this, just do we actually have a chat or not? Because I don't find it. And if we do, can you tell me where to find it?
We do. So when you just look at your Zoom, there's audio, video, and then there's a participant section, and then just next to it, it's a chat. It has like two bubbles with
I have a heart there and it says react, but that's
next to
okay.
React should be chat.
Maybe I see less than.
Alternative, you can just go to participant and click on one participant, and a chat will pop up.
Okay, cool. Let me do this. Aha. Okay, so yeah, I see this. And
then there'll be a drop list for where you can click everyone. You'll see chat from everyone.
Yeah. Okay. Good. Also, I don't see it right now, but maybe Vuyani, if you see anybody putting something into the chat, please do let me know.
Yeah, I'll read it out loud.
Oh, no, but I now see for the first time who's on the call. There's quite a few familiar faces here. That's great. Hi, everyone. Okay, so as to the questions, so I've never actually looked at that issue of confirming that you are not a computer from a smart contract point of view. But you're absolutely right. In a way, it can be seen in the way that I also described smart contracts earlier. That basically just says if something is done, then you then something else happens. Only that I don't know what kind of contract you are forming at that point. I guess that's my question back to you. You're just confirming that you are a human being so that you can maybe later down the line engage in the service offering that the website offers you or something. There's no contract formation at that point. At that point, I think it's just for security purposes for the website to make sure that who they are dealing with is first is basically a human being and not just a bot that is being used to for all sorts of nonsense on these websites, denial of services and all that. So while I understand how you connect the issue of smart contracts to this, because it is that if you click on the photo that shows a traffic light 3 times, then you can continue to be on our website, but it's not really a contract that you're forming at that point, right? So there's nothing really being exchanged. So I find it a little bit difficult to answer your question over and above that. Other than what you said earlier is probably also true that the smarter AI systems become, and provided that these bots are being run by AI systems, they will soon be able to fool even those systems into believing that they are dealing with a human rather than a machine. Sure, but that is also not necessarily a legal question. It's more a question about how the battle of technology, right? It's a constant catch up, and then there will be something new again that will hopefully make it impossible for these more advanced AI systems to overcome that kind of security feature. Anybody else?
Nothing.
Or my students on the call?
Nothing on the chat box.
Vanya, what confused you? Perhaps maybe we can unpack that a little bit more.
It just feels, yeah, it just feels like it's something completely intangible. It's like I can't visualize how it would, yeah, I just can't visualize it.
Not even with the analogy of the vending machine. Like, yeah, that is typically being used to bring this partially because it is an intangible tool, right?
Yeah. So let's say, okay, okay, let's put it this way. Somebody is coming to court and they are disputing their smart contract. What is the evidence that's going to be presented to that court? Like where, what is tangible that can be presented to the court to say, so, you know, Yaki Wessels, whoever's got to make a decision about there is a breach or this is a fake contract. How on earth does the judicial officer sit there, and what is the evidence that's put before the judicial officer?
It's a good question. Although perhaps maybe that is the one instance where I actually think it might be easier to gather that evidence, because the contracts, as I said earlier, they sit on the blockchain, right? So you can always go onto the blockchain, and the whole history of the contract as it developed. First it was just put there, then someone did something, then something was executed. So that whole history will be stored as a record on the blockchain. So it should be quite. How does the
judicial officer access the blockchain? I mean, what is going to be brought to court? Is it?
Yeah. Okay.
Is it a printout of? Is it a picture like you showed us of that code? Does the judicial officer have to have a laptop and somebody shows them something? How do we know that this is a real thing?
Right. You do know, though, that we are now going into kind of law of evidence sort of areas that are slightly beyond my area of expertise. But yes, I would assume that it is kind of like a screenshot of that code, and and some form of kind of printed version of the smart contract as it sits on the blockchain.
Okay, so we need to find somebody who wants to take someone to court so we can test drive this.
Right. Yeah. So your main issue is about, okay, how is any of this be proved?
Yeah, I mean, I think that's the bottom line. How is it real?
Vanya Jakia. The next question is how do I know the party is the party? Yeah, who's the parties? Oh, and the jurisdiction, Leta is saying here on the side. Jurisdiction will definitely be another one.
Yeah. So who are the parties? So the parties, again, that should be visible from what is being kind of captured on the blockchain. I think next time I need to go into more detail of how the blockchain works, and maybe that makes it a little bit clearer, although there is a risk of confusing people even more, and that's why I left it out in the first place. But the records are stored like as they are on a server or on a computer. The records of like the details of these things are being stored on the blockchain. So you will get it from there. Subject to Vanya's earlier comment, well, the practicalities of that are difficult. Jurisdictional issues, yes, absolutely. I think was it one of these on the list? Let me just double check. I think it's jurisdictional issues.
Yeah, it
absolutely.
Was on the top of the list.
Yeah, exactly. It's absolutely one of the main issues, because more often than not, these cases transcend obviously national borders. I talked about as if all these cases are confined to like a South African consumer and the South African contract partner, but that is more often than not the case. But I can raise these jurisdictional issues for you. I don't have solutions to you because they do not yet exist. It's and to the extent that the way in which we normally deal with private international law and conflict of laws doesn't give us the answers to that. We have that as an existing set of laws that already deals with these cases, but to the extent that that doesn't give us answers, we have to formulate additional ones for this context.
Thank you. From our side, because I'm sitting here, all the regional court presidents we're at the meeting, so we're sitting and watching the webinar together. I suppose from our side, we just want to say thank you. You did explain it very systematic, and I do think it helped the way that you explained it to explain why a smart contract is not really smart and maybe not a contract either. Thank you. But a follow up would probably be a good idea, including the evidential one, Vanya.
Yeah, I agree.
And then we need to go into the AI issues as well, because that is the disrupting factor as well with everything these days.
Exactly. And I think especially increasingly around evidence. I mean, you know, what's real and what's not real these days.
But if I can just come in there, if that is something that concerns people on this call, and by extension, those are sitting there in your room and watching the seminar, it would be useful if we could kind of have a almost like a what are the FAQs, or at least the questions, so that we then can get to addressing some of these questions in the actual seminar. So it would be good to have that almost a preliminary kind of what questions do you have, and then we can knit another webinar around that, especially when it comes to AI, because it's so wide a topic. I mean, that could be otherwise a webinar of hours.
Sure, I think that could be done. I'll send an email after tomorrow morning to the attendees to ask if they have questions relating to that, and then we just collate them.
To say, I just wanted to say, it appears as if the offerer is in a better position than the offeree, that is the person who then has to accept the contract, because that blockchain, whatever, when the evidence issue comes into play, you depend on what the person in charge of the blockchain is having. I mean, you simply pressed on the phone or whatever the button and the contract was there and your money is gone. And now when you start to cry, you say, but you bank, you have taken so much of my money. And the bank said, but you agreed. And they like, so they are in a better position. And I doubt if then the whole contract should really be seen. I don't know what to say about it, but the whole contract appears to be a sham in favor of the one who has got the capacity to offer, to trade. We end up being swindled. It means the other party, can be easily swindled, and you don't have anything to push forward, and he might be having everything to put on. And even the question of the correction of the mistake, I don't know after how long, because you might be starting to realize after you have performed, and after a long time, then hey, the thing does not end now. And it might be seen as if you were, by counter-performing to a certain degree, you were agreeing to that when one was actually not. So the whole issue of this thing is bad. I don't know how to, when I would be adjudicating on such a thing, how I would actually adjudicate on it. Thanks a lot, but yeah, it has given us something much more better to look at if it were to come before me or whatever, and even better number of questions to really interrogate the one whom I consider to be having better muscle than the one who appears to be a victim right from the beginning and maybe to the end. Thanks.
Okay, thank you.
I think we should close the session since we don't have any more questions, unless somebody pops up a question quickly at the chat box or just unmutes themselves. But I'm just going to use my duties as a facilitator and also squeeze in a question. So Toby, I just wanted to find out, how does one have access to a blockchain? Say I have a transaction with Takealot. Is the blockchain with Takealot, or is it
Okay,
my
I'm getting.
server thing somewhere in India? I don't know.
Okay, so I'm getting now, because your question is now the second question going into the same direction, and that is that what I think I may have confused people a little bit now into thinking that every electronic contract or every contract concluded electronically is necessarily a smart contract that resides on the blockchain. And that is not the case. So that does not mean now, what I want to not get across here is that all of Takealot's business, I used them to explain electronic contracts at the beginning, but then I moved from that to a subset of contracts, and that is smart contracts. So Takealot doesn't conduct, at least to my knowledge, does not conduct all of their business via the blockchain. So they are not using like smart contracts in the way that smart contracts are being defined as something that resides on the blockchain to do their business. They are contracting electronically, but still everything is happening on the servers and not on some blockchain. So that is the first thing. I just want people to understand that you only have a smart contract if that is one of these pieces of code that are automated and are residing on a blockchain, which is not the case with typical online merchants like Takealot and Amazon and others. So that means that your question can go into two different directions. So the one question is, how do you get access to the blockchain, which is not the case for your contract with Takealot, or how do you get access to the information that Takealot has if you were to use Takealot as a platform for purchasing that? And there's different means of accessing that, and the one is that for accessing a certain platform for blockchain, you would have to run a software on your computer that connects. How to not make that too technical? You would connect as a node to the blockchain, and then you can kind of add stuff to that blockchain, and you can also access the other blocks on the blockchain to look at what is stored in these other blocks, and there you would see what is in contracts that were previously concluded on that blockchain. As to otherwise, if it comes to just getting proof for what some normal transaction with Takealot, again, that sits on the servers, and like the normal rules, normal electronic rules for gathering evidence would apply. This is outside of the blockchain context.
Thank you for that clarity.
Thank you. My name is Francis. I'm from Kenya, and I'm most grateful for that last bit, because really, it will appear then that for one to get or to understand these smart contracts, and thank you so much because of introducing this, because it was going to come to court and someone is talking about smart contracts and you're wondering whether it's just the normal electronic contract. So you have explained it. So you would then probably advise that for one to really understand smart contracts, I've heard you allude or talk about blockchains. Blockchains is something one has to understand because it goes hand in hand with smart contracts. You have to get it well. And then there's the aspect of the coding, the issue of something around that area. So I think probably you wish to, in future, talk a little bit about those two issues then before we get into the issue of the smart contracts. But I'm very, very useful, very, very grateful. The other issue which I wanted to ask was, now if someone was to bring this contract to court, and the other party, the opposing party, was then to say, I mean, this is not a contract. They'll raise a preliminary objection and say this is not a contract because a smart contract is not your normal contract. I mean, again, would you be able to say how the court will go about this issue? Because you've said both of them, it's either the contract or it's not a normal contract as we understand it. Otherwise, thank you so much.
Okay, great. Thank you. This is very helpful. I'm glad I was actually triggered to clarify this, because it would have been a pity if that misunderstanding would have prevailed. Sorry, I lost my train of thought there. Can you just repeat the question quickly?
Yeah, first that the last one, or the one about blockchain, and
the last one.
The
last one. The blockchain that yeah.
There is the aspect of a smart contract not being a contract as such, and also being a contract in the normal way that we understand it. So if someone were to come to court and a plaintiff or a first party files a case and says this is a contract that they would like enforced, or there's something about the contract, and then the opposing party says, after all, a smart contract is not a contract, and indeed this was a smart transaction. I mean, just how will it go? How will the court decide? Because a preliminary objection would mean that the case will not go on if it is upheld, or the case goes on if it is dismissed. How do you go then to say that there is a contract here or there is no contract here? Yes.
Right. Okay. Thank you for repeating this. So, okay. So I guess the best answer to this is that when I say a smart contract is not a contract, I don't mean that there is not a contract at all, but that I want to see that the what is referred to as smart contract is simply a piece of software that executes the contract. It is a tool within the context of a broader contract. So you would still use your normal requirements for formations of contracts. You need an offer on the one side, you need an acceptance unconditionally on the other side. You would still have to gather all that. You need to still determine whether you have a contract or not, and that can be by technical means, by data messages or not. But that is not what a smart contract is about. Smart contract, and that's why it is such a misnomer, is really just a way within a contract to make some of the kind of execution of the contract more efficient, quicker, these sort of things. And that is what I want to try, what I want you to understand. So someone cannot just say, just because the use is being made of a smart contract, and because I said that's not a contract, that doesn't mean that there is no contract. It just means that part itself is not a contract. We still have to use our normal tools to determine as to whether a contract was formed or not, and then apply the law accordingly. I hope that makes sense. I was rambling a little bit, but it's quite important for me that just that smart contract part is not a contract, but that doesn't mean that the whole arrangement between the two parties involved doesn't amount to a contract. Does that make sense?
Thank you so much. I get it, yes.
We have gone way past the intended time. I think we should end the session here. I am now clear, Toby, on what's the difference now. And for those not entirely clear, the slides and the recording will be available on the Law Library website. I'll just drop a link just below, or just send an email tomorrow. Again, thank you, Prof. Toby, for this wonderful session. I hope the Magis will get some of these matters in their courts, so we can have interesting jurisprudence. Again, to our regular attendees, we are eternally grateful for your participation and supporting us. Thank you, everyone, for joining us. Enjoy your evening.
Thanks, Vuyani.
Thanks all.
Thanks, Toby.
Thank you. Bye.
Bye.